Good morning. Thank you all for coming. I hope you've had a chance to have some of the fantastic breakfast that Saltbox Kitchen helped us to secure. And you're incredibly welcome this morning. My name is Diane Proctor, and I'm here really to do the introducing and passing around of a microphone, and nothing more intellectually laborious than that. Before I begin, I want to thank the library for making this extraordinary facility available. And they now have an in-house camera so that we don't have to get everything set up as we so often have. And so we're so grateful for their resources and their work. I also want to thank the people who've made all of the food and everything else possible. Melissa Sawfield, wave Melissa back there, and Stefan Bader, yay. And the people who are managing, I mean, Carlin Reed does everything, and she's over here right now. Carlin and Emily Wheeler and Nancy Confey are managing the online participants, and there are many. So this is another wonderful way for us to be able to contribute. Judge Gertner and I were just saying to each other, Zoom is really terrific because it allows us, as she so graciously said, to be, we don't have to have on fancy clothes, at least below the waist. So, pajamas on one end and our nicest apparel on the other. I'm here just really to introduce John Kratzley, Judge John Kratzley, a friend and a remarkable man. He served on the Massachusetts Superior Court for years, serving as chair of the Superior Court Committee on Alternative Dispute Resolution. From 1999 to 2004, he served, and listen to the number of chairs, he served as chair of the Massachusetts Supreme Judicial Court Standing Committee on Dispute Resolution. And since his retirement in 2011, and in 2011, he has served as a full-time arbitrator and mediator at JAMS, which is an organization that specializes in arbitration. He's a lecturer at Harvard Law School, and since 1972, an adjunct professor and lecturer in law at Boston College. His role as director of the judicial process on the trial courts clinic at Harvard. We okay? All set? No, John. Yeah, listen, I had 2 pages and he said, oh, way too much. So I mean, really, if you look John up, they're just pages of accolades. So anyway, I'm cutting it down. And I cut a lot out. In his role as director of the judicial process of the trial courts clinic at Harvard, Judge Kratzley oversees students working in clinical placements with individual judges. So I think his work with students must be seminal to the kind of important efforts he undertakes. The recipient of numerous awards, most recently the Massachusetts Bar Association's Professor Frank E.A. Sander Award in Dispute Resolution, the Judicial Excellence Award at the Massachusetts Judges Conference, and the Lifetime Achievement Award by the Frank J. Murray Inn of the Court. And Inn of the Court, that reminded me of England. So I have to ask you, John, whether this is, I'm sure it's not, but Inns of the Court, right? For 34 years of judicial service in the District and Supreme Courts of the Commonwealth of Massachusetts. While on the Superior Court, he served as a regional administrative judge in Norfolk and Suffolk counties, and as chair, again, of the Supreme Judicial Court Standing Committee on Dispute Resolution. Judge Kratzley received his LLM from Georgetown University Law Center and his JD from the University of Chicago Law School. He received his bachelor's degree from Swarthmore College, but perhaps most importantly, he is our famous judge. An active participant in Concord town efforts to serve its citizens. And he and his wife, Holly, are both people who bring wise and thoughtful direction to our town. Thank you, John.
Well, I tried to stop Diane because that's just way too generous. And in fact, it's gonna, when I introduce Judge Gertner, she's got like 10 times more of those awards, and they're not even in my introduction. I just finished teaching a trial advocacy class at Harvard Law School, and I told my students, when you make an opening statement, when you make your closing argument, don't use your notes. Sure, is that better? Okay. All right, great. So that's another lesson for the trial advocacy students. But anyway, I'm going to break all my rules. I have a few notes. So I'm John Kratzley, and my wife Holly and I are members of the league. She's far more visible. I'm like a phantom member of the league. But we're very pleased to be part of this and have the opportunity to introduce my friend and colleague, Judge Gertner. Last time I introduced her was another important Concord organization based here. It was a couple of years ago for community. Oh yeah, okay, great. Okay, is that better? Okay, great. Last time I introduced Judge Gertner, it was another important Concord organization based here, Communities for Restorative Justice. And her talk then, it's even more urgent what she's going to talk about today. Can our courts, can our American justice system meet the challenges of the threats to our democracy? So it's urgent, and we're happy that she's here. She's a graduate of Barnard College, Yale Law School. She had a distinguished career, trial lawyer in civil rights work and criminal defense work. President Clinton appointed her to the federal court here in Boston, where she served for 17 years, recently retiring to join the Harvard faculty. And I can say, just because I watch these things, these students line up for her courses there. You all know her from her writing in the Boston Globe, the New York Times. You've all heard her on WBUR. You know that she's a much demanded panelist and speaker, and in fact is on another panel later this morning, where her topic is very similar to what you're going to hear about today. Have the courts been captured by corporate interests? So it's my great pleasure to introduce her. I'm being scrupulously careful about the time today. So Judge Gertner, welcome to the forum, to the Goodwin Forum, and welcome to the Concord League of Women Voters, Concord Carlisle League of Women Voters.
Thank you. Okay, I'm going to direct it right to there. Although no one ever said that I didn't have a loud enough voice. I have to begin with what my husband, who denies saying this, but I have said it now, but I believe he said it as soon as I left the bench. One of the problems with being a judge is that the only way you can speak is through your opinions. You can't, I did some op-eds, but you have to be careful about how you speak. And now John says that now that I can speak, I can't shut up. That's one thing that he says to me. The other thing is he says to me that I've never met a microphone that I didn't like. And this is all true. This is all true. And so being a judge was very constraining because, you know, you just couldn't go off. Some judges do, but I wasn't in that category. I wanted to, this is a very difficult topic to wrap your head around. And so I brought all of my notes, only some of which I will ever look at again. I want to start at the top, which is the Supreme Court and what's going on with the Supreme Court. And then I want to talk about what's going on in the lower courts with respect to the Trump cases, give people some sense of what's going on. And then I want to broaden my focus to the question of whether courts can be the first line of defense in a democracy. So let me start with, this is the report of the Presidential Commission on the Supreme Court. I was on that commission. It did its work in 2021 to a degree before the full scope of what we are dealing with became clear. It was a document, it was a commission that Biden put together for the purpose of just airing the issues. Now that I can actually spin this in two directions. On the one hand, some will say he put it together in order to stop the discussion about the Supreme Court in the campaign. He was putting this to silence that. But on the other hand, it also was the idea of having a deep discussion about the Supreme Court out of the political sphere. And in fact, the commission was extraordinarily even-handed. There were originalists, there were people who were very conservative, there were people who didn't believe the Supreme Court should change at all, and then there was me, Larry Tribe, Sherilyn Eiffel of the NAACP Inc. Fund, and a few others like that. But it was very balanced. Its purpose was not to come up with any recommendations, actually. We were only supposed to sort of flesh out what the issues were. So what were those issues? And this is part of the dilemma that we're facing. We have, in my view, this is an editorial comment, the most powerful court in the world, with a court of complete impunity for various reasons, and now one of the most conservative courts in our history. But the court that we were talking about, this is a court that is smaller than other Supreme Courts. 9 is actually a small number, that has lifetime appointments. Every other Supreme Court, High Court, has term limits. And lifetime, when the court was fashioned, you didn't believe that you actually needed to come up with term limits because people didn't live so long. That's not the case today. So there's never been a court with no limit at all on the amount of time someone can serve. There's no court that has the power of our Supreme Court. That is to say, many Supreme Courts, high courts, can be overturned. Portions of what they say can be overturned by the legislature. The legislature has the final word, or the parliament has the final word. So this is a court that has the last word on the Constitution. And it's also a court that can pick its own cases. It's not obliged. There's some areas where they're obliged to take cases, but most areas they actually can pick their own cases. The combination of no term limits, small court, pick their own cases, no appeal from them, has never been a recipe for disaster until today. And why is that? Well, so the Presidential Commission looked at the ethics of the court, looked at the way they select their cases, looked at transparency, looked at term limits, and looked at the size of the court. On all of those measures, essentially, the commission said, there's nothing we can do. And there's nothing we can do, either because change required a constitutional change, or because the feeling was that once you engaged in a discussion about the court, it would open up even more political battles. My part of this was on the size of the court. That was the subcommittee that I was on. And I actually had no opinions, which is remarkable for me, as many of us know. I had no opinion when we started. You know, that doesn't usually happen. Another wonderful quote from my father, who said that some people had hardening of the arteries. I had hardening of the opinions. You know, but I was on the committee that was dealing with size. And the size was the only issue that many of us were dealing with that did not require a constitutional amendment. Term limits, although some people have different views of it, do require constitutional amendment because the Constitution talks about appointed for life. There are ways of getting around that, which we could talk about, but that's a constraining issue. Changing the jurisdiction of the court, one could do, but the feeling was that in this political debate, who knows where that would go. But size seemed to be something that we could do that wouldn't require a constitutional change. And why is the size of the court important? As I said, it's the smallest court in the world. Every other high court has more than 9 members. 9 is not a magical number. The court had been at 6. The court has been at 10 at one point. 9 is not a magical number. Congress could change the size of the court tomorrow. Congress could come up with a way of sort of staircasing the changes in the court. So it could be 2 years under two appointees under one president, and then 2 under another president, and 2 under whoever's after that. yes, it could lead to sort of a nuclear war of size, so that, Democrats would increase by 2 and Republicans will suddenly increase, by 2 more. And by the next millennium, we could have this, court the size of the League of Women Voters. um, but the feeling was, and because of the notion that there could be a quid pro quo and a back and forth, that this is not something that we should engage in at all. The first draft of the section on size said we could expand the court, we should expand the court, but don't do it because of the politics. And Professor Tribe and I, Sherilyn Eiffel, Andrew Crespo at Harvard, a number of us said we couldn't sign on to a report that said this is a deeply flawed institution, nothing we can do about it. And why then did we say we should expand the size of the court? Well, there were 3 reasons. One is that, in fact, and because everyone harked on the notion that this would be Democrat court packing, as the Republicans had done, court packing. So the answer to that was the court has been packed. The court has been packed, not illegally, but by violating norms. You remember the story. Scalia dies during Obama's term. Obama proposes Merrick Garland. Senator McConnell will not give Merrick Garland a hearing, not a hearing. As a result of that, the position remains open until Trump is elected and Justice Gorsuch is put in that position. So it was a manipulation. The Constitution doesn't say one way or the other, though. I mean, what McConnell did was not illegal. It was just violated the norms of practice, as we've seen happening more and more. And so the first person that goes on the court is Gorsuch. Then Justice Kennedy decides to retire, clearly intending to give Trump a position. In fact, there are some discussions that Kavanaugh, he had Kavanaugh in mind, and there were, I don't know whether any of this is true, and there were assurances that Kavanaugh would get that position. So Gorsuch, then Kavanaugh. Then Ruth Bader Ginsburg, who was my mentor, dies. There's a whole other discussion about whether she should have stayed on as long as she did, but she dies. She dies, I believe it was in late September, and within a month, Amy Coney Barrett is selected and confirmed. The concern about that had blocked Merrick Garland, McConnell had said Merrick Garland shouldn't get on the court because we shouldn't have a hearing because it's too close to the election. Amy Coney Barrett gets on the court while people are voting, early voting. So the notion that the Democrats would be packing the court now, it seems to me, is an empty statement. The court was packed. 3 extraordinarily conservative jurists, which I'll talk about in a moment, all under the Trump administration. So that was reason number 1. It has been packed. And to some degree, a proposal of 2 and 2 and 2 is an unpacking. The other reason, and to some degree, this is part of the testimony of Professor Klarman at Harvard, which I found incredibly compelling. The Republicans are in all sorts of ways restricting the ability of the Democrats to win elections in the various states around the country, giving power to state legislators that they never had, grotesquely restricting the Voting Rights Act so that Southern states can do with respect to voting what they had been barred from doing under the Voting Rights Act, manipulating, gerrymandering, et cetera. So the configuration of state legislatures, of state voting patterns, means that makes it easier for Republicans to win in years to come. So the court is packed, and where ordinarily one would anticipate a certain amount of change as the administrations change, You add to that the concerns about manipulation of voting, and there will not be change. There's no question the court changes, not as fast as the electorate does. There's a certain ebb and flow of the court, but that's not going to happen for the foreseeable future because of the age of the justices that are on the court, A, and B, because of the ways in which elections have been manipulated in this country. And, and then the third reason is that these are young, relatively young individuals who are very different and were selected in a very different way than previous justices had been selected. And I can't begin to describe, that's actually my afternoon talk about the way they've been selected. You've all read about this. These were not, the Supreme Court, no matter how much people today talk about the liberal Supreme Court, the Supreme Court was essentially moderate right to moderate left. And while it swung, it never swung much wider than that. When the abortion decision came down, but then followed was nearly 15 years of restrictions of abortions. When there was the criminal law revolution and the right to counsel, the concern about forced confessions, there were then, 15 to 20 years of restrictions of that. So this has never been a court that was wildly liberal or wildly conservative until now. This court was selected by the Federalist Society, selected. Trump was quite open about outsourcing the selection process to Leonard Leo and the Federalist Society. All of them were on the Federalist Society. You can say, this is fine for you to say, Gertner, you're this big liberal, right? I mean, I was an ACLU member. My husband was the legal director of the ACLU. So it's time for the other side. Well, that's not completely true. The Supreme Court justices, Ruth Bader Ginsburg was actually a moderate, had been a moderate on the District of Columbia Circuit. Justice Souter was appointed by a Republican, was a moderate. Most of the even Thurgood Marshall was cautious on the Supreme Court. There's not the same kind of orthodoxy on the quote left as there is with respect to this group on the right. And what do I mean by that? Scalia was an originalist, but as he famously said, he was an originalist but not crazy. And what that meant was he believed that the original intent of the Constitution would control, would restrict what judges did, rather than the counter argument was a living Constitution that would enable the Constitution to grow. I feel like answering any phone. I'm totally tied to my phone and I feel like going and picking it up and answering it. Although you have to do what I do, which is I have a different ringtone for each of my kids. So I know what to answer and what not to answer. So this group, I want to suggest then again that this group is very different than other appointees, not just that they are young and not just the way they were appointed, but they are really very different. And I wanted to talk just briefly and get into the weeds about, as I said, originalism, which sounds like a way of restricting judicial interpretation, so that you're bound by the meaning of the Constitution or the intent of the words when they were enacted. You can't go off on some new interpretation. So but this is a different kind of originalism. The originalism that Alito talked about was essentially an originalism that said, if you're going to create new rights, I'm not going to be with you. If you're going to create new rights, we're going to look only at what the Constitution had in mind way back when it was promulgated. The problem with that is that the new originalism also doesn't believe in precedent. The combination of an originalist point of view and not believing in precedent means not just that we're talking about new interpretations, which you'll reject if they are not consistent with the Constitution, but they are willy-nilly, heading straight into undoing established interpretations of the Constitution in areas that you all know about, but in fact are more broad than that. not just gun rights, not just abortion, labor law issues, administrative issues, environment issues. So it's not just, one could understand originalism. We have to look at what the Constitution was intended, what the words mean and what the intent was. You have to obviously begin there, otherwise this document doesn't constrain power. But what they're saying is, this new court has a right to undo the older interpretations. And that's chaos. That is absolute chaos. I should say the Bruin decision, which was the case with respect to gun rights, is chilling, I say, as a federal judge who presided over gun cases in my courtroom all the time. It's chilling because aside from the fundamental issues with the interpretation of it, but it's really going to cast a pall on regulations today with respect to guns that didn't exist at the time of the Constitution. It's appalling with respect to women. There are very creative Harvard law professors who said, okay, we're all originalists. I'm going to now look at the original interpretation of this or that, and we'll make use of it for the issues that we think are important. And the only problem with that is that women are not in that calculus. Women are not in that calculus. At the time the Constitution was drafted, women were property. Blacks were property as well, but the 13th, 14th, and the 15th Amendment did address that. But women were property and didn't begin to get rights until the 20th century with the 19th Amendment and the vote. So originalism is the obverse of everything that Ruth Bader Ginsburg did in her life. And originalism threatens to undo all that we care about. The abortion decision was classic in this regard, and the chaos that it has unleashed is something you all know about. So I go back to my first issue. This is a court that was packed. This is a court that was packed, combined with political changes in the legislature, state legislatures, is going to mean that this group of people will be on the court for the foreseeable future. My lifetime, surely the lifetimes of our kids, 30 years. It would be one thing again if they were if they were Alito originalists, but they are not. They are hell-bent to undo really decades of law. I actually, just as a footnote, I actually find it hard to teach these days. And I don't know whether, John, you have the same problem. I mean, you tell the students that there's a stable body of law that you can interpret and can, expand incrementally. How can you talk about a stable body of law, and how can you talk about incremental when in 3 years, the numbers of precedents that have been overturned is really shocking. So what do we do about that? What is its impact on the broader population, on the lower courts? Well, now I wanted to talk a little bit about the Trump cases that are before the Supreme Court. Having absolutely no crystal ball, having guessed wrong about major things over the past couple of years, but that doesn't stop me from talking about them. As my husband will say, nothing stops me from talking about them. So the immunity case, the argument that Trump is immune from prosecution because these are things that happened while he was president. That's not formally before the Supreme Court yet. The January 6th case in the District of Columbia, he raised that in that case. That's before the District of Columbia Circuit. We anticipate a decision any day now. The question will be whether the Supreme Court will then grab that decision or wait until it makes its way through the full court and then to the Supreme Court. If it waits, obviously it'll be too late. That will mean that the January 6th DC case will wait, will back right onto the election. And who knows what will happen at that point. I have no idea, I have no predictive capacity here. I actually believe that won't happen. I believe that the court did not grab the case, the Supreme Court did not grab the case from the Court of Appeals when they were asked to do so by Jack Smith. And I believe they didn't do that because the DC Circuit, the Court of Appeals, was actually moving expeditiously. And that, I mean, that's very interesting. They're letting the court move expeditiously. And my intuition is only that Trump will lose that issue because the breadth of his argument is so absurd. You all recall the SEAL Team 6, killing an opponent. And does that fit within presidential immunity? And his lawyer had to equivocate on that. What lunacy. So I actually think that that's not even a close argument. And unless the Supreme Court is really political, and who knows, they will dispense with it rather quickly. That will mean that when there's a District of Columbia decision, which I really anticipate any day now, that the Supreme Court would either decline to take it or take it in an expeditious fashion, but they could well decline to take it. That is a relatively easy issue. The Colorado qualification case, which is before the court, is very unclear at this point. At one point, I wanted to do an opinion piece that would say, okay, Supreme Court, I'll stop criticizing you, and all the other commentators who criticize the legitimacy of the court for some of the reasons I've described will not do it anymore, and will not do it anymore because if you rule that he is not qualified under Section 3 of the 14th Amendment for having engaged in an insurrection, that will hit it out of the park. Nobody will question, even though they should, issues that you're addressing up until then. I actually don't know which way that would go. That kind of decision would have put an end to Trump's candidacy. Do I think that that will happen? No. There are lots of ways. It's simply too big a decision for a court. And I think that they would understand that. There are lots of ways they can get out of that issue. The lower courts have been dithering about it, questions about what is engaging in a insurrection mean when he wasn't actually there. Can they play around with what the level of participation has to be with respect to an insurrection for him to be disqualified? They can say that the Constitution doesn't enforce itself and that Congress has to come up with some way of enforcing it. They could say that there has to be a conviction. There are all sorts of things they could say, which interestingly enough is inconsistent with originalism. Interestingly enough is all inconsistent with originalism, because the disqualification of Confederate soldiers from holding office took place without convictions, simply their status, and they were disqualified, and no further interpretation was necessary. Now they were the engaging in this insurrection could be a difference between could spell the difference between the Confederate soldiers and Trump, in the sense that they were actually bearing arms against the US. But I think, as you all know, numbers of originalist scholars have suggested that the originalist interpretation of the disqualification clause should be applied against Trump. So that is a very complicated array of people on various sides. I don't know what they will do. My instinct is that they will not disqualify him, but that would be interesting. There's a little sleeper of a case that this is before the Supreme Court, which is an appeal of one of the January 6th demonstrators, a guy named Fisher. And Fisher was convicted of obstruction of justice, obstructing a proceeding for being in the Capitol, and his actions contributed to the delay in the vote count. Court has taken his case on the issue of obstruction and what the scope of obstruction means. One of the cases against Trump in the January 6th proceeding is an obstruction count. And so the court could narrow that obstruction issue so that it doesn't, and wipe out numbers of convictions for the January 6th defendants, and have implications for Trump's case in the District of Columbia. It also could, their consideration of this issue could also delay the case. And once the case is delayed, who knows what would happen. I actually think Trump is different than the cases, that his case is different because when you had someone running into the Capitol who was obstructing a proceeding, but who didn't necessarily, wasn't one of the original conspirators, who didn't necessarily know that if they made a fuss, Pence could be hurt, the count would be delayed. They were just, obstructing whatever was going on. The case against Trump is broader. It talks about the obstruction at the Capitol being one part of a plot that alongside of false electors, alongside of trying to persuade Pence not to do the counting. So the allegations against Trump are actually broader. One can say that some dumb demonstrator didn't really know what he was doing and really had no intent to obstruct the proceedings, but that would actually be more difficult to do with respect to Trump. So the obstruction issue is likely more to be a delay because it certainly has implications for the January 6th case. The classified documents case is in La La Land. La La Land. And I get to talk about that in a moment because one of the questions that I wanted to answer is how does what's going on in the Supreme Court affect the lower courts? And Judge Cannon is an example of that. She is simply, I can talk like this because I'm no longer a judge. Who cares? She's putting her finger on the scale from beginning to end. The classified documents case was the easiest case of all. You shouldn't have had those documents. And you couldn't say, whoops, oh my God, I was packing my pajamas and there are a couple of nuclear secrets in it. There was no whoops possible here. Although actually Trump had an explanation like that, which was hysterical. I didn't think I didn't think I was defeated. I was packing really fast. So I put in, pictures, my underwear, and nuclear secrets. I'm sorry. That there's no question that he can't say that because of the evidence of his intentionality, the evidence that he resisted when that whoops might have applied to the first inquiry about whether or not you had classified documents. It really doesn't go beyond that because then he was intentionally putting things away and putting things in purposely putting them in different places like those bathrooms. If someone wrote a play about this, you'd never believe it, right? In those bathrooms, the bathroom with the chandelier, and I mean, it's really quite extraordinary. So that is actually the easiest case. It's complicated by difficulties with respect to classified documents. There are rules about who could see them. There are rules about who can get a clearance, security clearance with respect to that. But those never pose the kinds of problems that this judge is allowing for. If you recall, the Boston Marathon bombing case had classified in some security information. Tsarnaev had some encounters with the CIA, or the family, I guess, had encounters with the CIA. So there were some issues of what could be shown to the defense and what could not. They can be dealt with in a week. In a week. This woman is simply putting her fingers on the scale. Who knows when that case would be tried? So the January 6th case could be wrapped up by the obstruction issue and not the immunity question, but certainly could be wrapped up in the sense of delayed because of the obstruction question. The Eileen Cannon's case will probably go to trial in the next millennium. And so what do we have is the Georgia State case. The Georgia State case, deep sigh. That case was likely to take some time in any event because of the complexity of the charges. The accusations now against Fani Willis, in my view, actually shouldn't affect the case itself. It's not like she was having an affair with one of the defense lawyers and therefore learning things that she shouldn't have learned. She and the man that she was having an affair with, so-called, that hasn't been clear yet, were on the same side. I have to admit, and I'm not sure if this is a kosher thing to say, but again, who cares? A friend of mine in Atlanta, I wrote her about this, and I said, what do we think about Fannie Willis and all of this? And she said, listen, Trump has been able to engage in nookie with whomever he wants without consequences. Fannie is having one, so big deal. The problem is that it doesn't work that way. There is a possibility that she could be disqualified, and I'm not sure what this law is, but someone wrote that were she disqualified, the whole office would be disqualified, which would mean that case would be delayed. Were she to resign, it would actually not have an impact, the same kind of impact as if she were disqualified. In other words, if she voluntarily resigned, or if the person that she's having an affair with voluntarily resigned. The ethical issues, to the extent any of this is true, actually don't bear on the case. They are completely a sideshow, but they bear on her participation in the case. And so that could delay it. That case wasn't going to happen very quickly, but the significance of the Georgia case is that whenever it happened, were there to be a conviction, Trump could not pardon himself. So that case may not, even if delayed, would be an issue for the former president. And finally, New York has a case, Alvin Bragg's case, which was a state case based on the money that Trump gave to silence Stormy Daniels, rather than let that affair become public. That case can easily go forward and may well go forward in March or April, but it's not a case that would be disqualifying. It would be a case that would be troubling, but it's not clear its impact on Trump's nomination and the election. The other cases were civil cases, which while they give a window into what litigating against Trump is, they really don't have a fundamental impact on his nomination or his election. So I talked about the Supreme Court. I talked about the cases before the Supreme Court involving Trump. And then the question is, what about the lower federal courts? Very interesting. I had been a civil rights lawyer and a criminal defense lawyer before I became a judge. And although there really was no opposition to my appointment in Massachusetts, there was opposition in the rest of the country, but not here. I got letters from prosecutors and defense lawyers who prosecutors whom I had opposed, who supported my nomination, Bill Weld, notably. And in fact, over 17 years, I did what I could to be fair, understanding that I was constrained by the law. Now, the law that I was constrained with was not a law with which I fundamentally disagreed, abortion rights, discrimination law, but I had a death penalty case, and I had to grapple with whether someone who was as opposed to the death penalty as I was could try someone for the death penalty eligible case, and should they be convicted, announce that the death penalty. I had to do that. I had to be able to say that, otherwise I couldn't take the oath, and I felt constrained by that oath without a doubt. I think all of us who were Obama, Clinton, Reagan, Bush, Republican, Democrat judges felt that way. You did what you could in an area of discretion, but you were deeply constrained by what the Supreme Court was doing, what Congress was doing. The judges appointed by Trump. There are two structural differences between them and us. And us, I'm putting in the category of appointed people, judges appointed by any other president. Any other president other than Trump. What is the difference? I was selected not because I was an ACLU member, but despite it. I had to show to the Congress, to the Senate rather, that my views would not I would not be enacting my views as a judge. They would certainly bear on what I saw and what I did and what I understood, but I did not believe that the outcome should be precisely what I thought was fair when the law went in another direction. I'll tell you a little bit about that death penalty case in a minute. I was not selected because I had been an ACLU lawyer, just the opposite. Most of the judges on my court were selected in direct proportion to their never having taken controversial positions. I had a little bit more problem in that regard, but they were selected. And again, Republican, Democrat didn't matter. The judges that Trump selected were selected in direct proportion to the positions that they had taken. Amy Coney Barrett had written about being a Catholic lawyer. That's not my saying, that's an article, how to be a Catholic lawyer, how to deal with the death penalty, how to deal with abortion. Gorsuch had expressed his views about the administrative state, his skepticism about big government and the administrative state before he went on the bench. Kavanaugh likewise had expressed his views. I believe he had expressed his views on abortion, but I'm not sure. But the lower court judges were selected in proportion to what they believed, their substantive belief. And we now know that there was actually a direct route to judging from the school you were in, Federalist Society. Federalist Society would propose judges for you to clerk for. You'd clerk for those judges. You'd become known because you were clerk for those judges, and then you were on your way to the Supreme Court. So the selection process has been different for the judges that Trump appointed, and I'll get to why that matters. And then these judges are judges, that is to say the judges appointed by Trump, and now I suppose the whole bench, are being judges at a time when there is no ceiling. What I mean is I had a ceiling. Precedent was my ceiling. The body of law that had been, not all of which I agreed with, the body of law that I had been dealing with, that we had all been dealing with, was the ceiling. These are judges without a ceiling. And what does that mean? It means that Judge Kaczmarek in Texas can decide that even though there is no precedent, even though there was no reason to question the abortion pill, that he can declare it illegal. The Supreme Court then invites reconsideration of everything in the same way that they are doing. And so that's troubling. Biden has appointed numbers of judges, so it's not all a Trump court. But I think that with respect to the judges, every time you read a decision like Judge Kaczmarek's decision, you say, I see he wants to be on the Supreme Court. And the way to get to the Supreme Court is through that decision. Judge Cannon wants to be on the Supreme Court, and the way to get to that Supreme Court is to do what she's been doing. So these are judges who are selected for different reasons than we were selected. And these are judges who are dealing in a world in which there is not a ceiling that we had been dealing with. So as to the question then about the role of the courts in a democracy, the role of the courts to constrain power, the verdict is unclear. Trump did not take over the entire court. There are judges that he did not appoint that are still there. The courts of appeals are uneven in the U.S., but have been exercising constraints. The court's reactions to the January 6th cases have been clear and indignant and outraged. So the answer is, but because the bench is mixed, their relationship to constraining power has been mixed. But in the final analysis, I do believe that the lower courts, the courts of appeals, and even the Supreme Court will constrain Trump. I do believe. What that comprises is another question, but I do believe that there is, what that is, it is, as I said, I think they will decline to immunize him. I think the obstruction issue may delay things. I think they're likely not to disqualify him just because of the enormity of that decision. But there will be constraints. Will these cases make a difference? I think that we're looking at trials at the same time as the election. Were Trump to be elected, he certainly could pardon himself for all the federal cases and drop all of those prosecutions. The state cases, however, are there. And so I think the answer is mixed. Courts should be constraining the exercise of power. I think that most will. But, you know, I don't have a crystal ball. I can only talk about what I can talk about. And at this point, it's not at all clear. Trump, I mean, the Supreme Court has to deal with an originalist bench, but also has to deal with an originalist scholarship that is actually inconsistent with his running for office, as I mentioned. So I can't say for certain that I know what will happen. It's also the case that judges evolve on the bench, and wherever you started may not be necessarily where you finish. And watching the things he says and watching the things he does may well constrain judges in a way that we didn't anticipate, but I don't have a crystal ball. Should we be worried? Yes, we should be worried. But we should be vigilant, and more significant for this wonderful organization, we must vote, because ultimately that is actually the power that we have. So with that, thank you very much. What a depressing, I'm going to drink now afterwards. This is way too early. Thank you.
I feel like we've just had a wonderful primer in law school. Thank you. Thank you so much.
Thank you.
Discouraging, so much of it is. We want to have a chance to ask questions, and we're going to have questions, we think, online with the people who've generously joined us there, and we'll have questions here in the audience. So Judge Gertner has, as she suggested, another appointment. So we have about 25 minutes for questions. So let's see what we can do, and let me start by heading out here. Yes, want to start?
Sure. Okay, thanks. Thanks so much. That was wonderful, and I've always enjoyed you on GDH and other places. So I was just curious, the process takes so long. I was always taught to respect due process and consider that an important part of our law. And I've been following this podcast called Prosecuting Donald Trump and you know, the ins and outs and trying to stay abreast. I do find it discouraging that given the level of offense that was created, that it's taking this long to hold him accountable. Is that just the way our system works and all is well? Or is there a problem there in terms of the way this is playing out?
In one sense, it's not unusual that things take this long. There was a strategic problem here, which is, so when Trump says that the DOJ was weaponized, I always want to say that if it was weaponized, these prosecutions would have begun the day after Biden was elected. And had they begun at that moment, when it would have been a very different outcome. We'd be dealing with trials now. If you recall, right after January 6th, it wasn't clear what Trump's future was. They could have basically dealt with him when he was down. But because Garland is so cautious, he doesn't, it wasn't clear what was going on until the January 6th committee. The January 6th committee issues its report. And in my view, I think that pushed him to then, you know, appoint a special prosecutor. The amount of time, given the complexity of the cases, is not a surprise. The Florida case is a surprise because, as I said, in my court, that would have been done in maybe 2 months, you know, but the others are not. And there is considerable complexity to these cases. He has the worst lawyers in the Western world. So I don't exactly, I mean, they no matter how much they fumble, they seem to hit on some arguments. And so the immunity argument is an argument. It's an argument that the court should dispense with rather quickly. Qualification issue is an interesting issue. The obstruction issue is I'm of two minds. Was a criminal defense lawyer and believed that criminal statutes had to be carefully and narrowly interpreted. And the Supreme Court has actually been doing that. So that may be a legitimate issue, which would undermine the January 6th case. But now the delay here is not really a surprise. What was a surprise was when they began.
Good question. Terrific. I'm going to start right here then.
Thank you. Wonderful remarks. A little discouraging, but thank you anyway. Where does the Chief Justice stand in all of this, and is he consequential?
Actually, I left out the ethical issues on the court. I was going too long. I think he's not powerful anymore. I think that he has lost control of this court. He's lost control of this court, as you can see, by the abortion decision. He wanted to affirm the specific facts, but not deal a bloody blow to Roe v. Wade. And he can't control the court that wants to deal a body blow because he's only one vote. He clearly has not controlled Clarence Thomas. I didn't go into that, but that is, my husband and I talk about this all the time. For 17 years, I was on the bench. I traveled steerage to China twice a year. I would teach women's rights in China, and I took very seriously the notion that no one could be paying me under the table, essentially. You couldn't pay for my speeches, but you could basically lavish me with gifts. I now wish I could redo those 17 years, because if, I could get and it was clear, by the way, that the people were supporting Thomas because he was complaining. I wrote a piece about this. He was complaining about the salary and his, and was threatening to leave if they did not support him. So it is, I don't think that Robert said it, and he has been able to control the judges. He doesn't have the votes, and he has not been forthright about ethics, which he could have been, by the way. He certainly could have been, but he doesn't have the votes.
Hi, Nancy.
Hi.
As someone who's terrified about the possible future of our country, I have been wondering a little bit, and wonder if you could say how you feel about the ways in which our state constitution may protect us that maybe the federal constitution won't anymore.
That's a great question. And as I said, John, can you raise your hands? John Reinstein, raise your hand. Yeah, there you go. So John and I, mostly him, litigated our state constitution actually predated the federal constitution. It's an older document. And over the past, 30, 40 years, it has been interpreted to give protections to Massachusetts citizens that the US Supreme Court has not given. Most notably, the Supreme Judicial Court declared the death penalty unconstitutional here. And so we have no death penalty under the state constitution. And if they declare something unconstitutional under the state constitution, there is no appeal to the Supreme Court. But perhaps the thing that we were the most proud of, the case that John and I were the most proud of, is a case that established the right to choose under the Massachusetts Constitution. So that there is no way that there can be an abortion restriction in Massachusetts unless there is a national abortion restriction. We are protected if the Congress enacts a national abortion restriction, which actually seems unlikely. There's no way that abortion can be changed in Massachusetts. Most recently, the Supreme Judicial Court just ruled that life without parole was not appropriate, was unconstitutional for 18 to 20 years old defendants. They had already ruled that under 18 it was unconstitutional. So our state constitution is giving us more protections, and our state Supreme Judicial Court is giving us more protections than the US Supreme Court. So yes, that could not be more important than there are state Supreme Courts around the country that are also acting in that regard, but as I said, in the case of abortion, I hate to use this verb, they could be trumped by a national abortion restriction. As I said, I don't think that will happen because there really will be people rising up, but the state is terribly important. Governor Healy has 2 appointments. Baker filled the entire Supreme Judicial Court. Baker has 2 appointments, has now filled, Healy has 2 appointments and now filled one of them. And we have hopes for who could be the second. But it could be an extraordinary court and a bulwark to Massachusetts residents from this Supreme Court. That's a great question. Thank you.
Thanks, Diane. Well, this is about the most erudite and most depressing Saturday morning I've
Thank
spent in a
you.
while.
Thank you.
So I
I'll
want
never
to
be asked back. That was the point.
and I wish that we could pack the court and pack them with people like yourself. But one of my concerns is that the voters from 18 to 30 who started off with incredible inspiration in our President Obama and decisions that were still being overseen by rational humans. That's gone. And there's sort of this debate of why bother to vote, or if we vote, will it matter? Like, what is the civic process now? Does it exist? And are we, as one end of the spectrum, because many that I speak to don't believe there's anything worthwhile in the Democratic route or the Republican route as functional systems. Not that right or left are wrong, but left being there's sort of right is now the middle, left is what could also be rational. But there's a lack of there. They don't know where they can see a political future, either for themselves to engage in or for the country. The irony being that because there's been such a process back to states, that it exacerbates the red and blue state initiatives.
Totally.
So I want to go back home and say to my daughters, okay, well, this is fascinating. Yes, it's as bad as we thought. Actually, it's worse. But there is a silver lining somewhere, and I still can't find it.
Well, we have 3 kids, 2 sons in their 30s and a daughter who's 50. I recommend you say to them what I said to my sons. My daughter was fine. I said to them, my sons, you vote for Trump and you're disinherited. I think we went immediately from rational argument to force. But there is a problem with younger voters, and somebody was saying that it may well be the election. I actually think Biden has been a terrific president, but this may well be the real lesser of 2 evils election. I do think that the president matters in all the ways that Biden actually reflects. There was an article about what he's done to the Affordable Care Act and issues about reconstructing our infrastructure. And it makes a difference in terms of judges. Another Trump regime will make a real difference in terms of the court. Biden has done everything he could to fill the court with nominees. I'm the chair of his committee to select federal judges in Massachusetts, and we have filled all the vacancies so far, pretty much all but one. So yeah, it may not be enthusiasm. There may not be enthusiasm for Biden, but he has certainly made a difference. And consider the alternative. Consider the alternative. No, but I do think that there is a problem with that generation. Think about the environment, think about civil rights, think about judges. No, there's, as I said, if I could think of something worse than disinheriting them, I will. But I do suggest force.
We have a couple of questions in the audience, and then we have one online. So I'm going to start with this question first and then go to the online.
Thank you. I'm concerned that rules that are unjust or make no sense um, uh, are flouted. People tend to lie, evade, surreptitiously work around them. People denied, people used marijuana for years and finally it's becoming legal. Another example is abortion. Women will never stop having abortions. They'll just go underground. So I'm concerned of what the future is. It's actually a similar question to the one just before. What do you see in 10, 20, 30 years as the Supreme Court goes farther and farther off into an extreme position and it doesn't comport with the way people live or want to live? I think it could be difficult. What do you think?
People talk about that all the time. Particularly, let's sort of ground it more. Let's say the Supreme Court in fact rules that Trump is disqualified. People said, well, there'll be a rebellion in the country. I tend to doubt that actually, but it's hard to know. We've gone through periods before when the Supreme Court has gone off the rails, right? We've gone, when Plessy v. Ferguson, the decision that enabled that enabled slavery happened, which by the way was an originalist decision, I hasten to say. Original interpretation, right? I mean, the country was founded when there were slaves, and therefore, how could it be that slaves were anything other than not citizens? It was an originalist interpretation. Dred Scott was an originalist interpretation of the Constitution. And there were, I think we're stable enough that there will not be widespread disobedience. But, I don't say that with total confidence because nothing that has happened over the past 4 years was anything that any of us would have predicted. I went to law school with Hillary Clinton. So there's actually a great story with my husband. Again, the night that she lost the election, John decided that we had to go to the city that was furthest from Washington in the world. And he went online and discovered that Hobart, Tasmania was furthest from Washington. And so sure enough, in early January, we went to Hobart, Tasmania. We did, however, come back the day after Trump was inaugurated so that we could participate in the Women's March. I think what you're describing certainly is a risk. When one delegitimizes, as I just did, the United States Supreme Court, you run the risk that its opinions will then not be credited and there will be a backlash. But if you don't criticize a Supreme Court that has gone awry, then you run the risk that these opinions stand without review. So I don't completely know the answer, but I think we'll survive.
We have a question online.
The questioner thanks you and asks, why do we lack so much confidence in the legislatures in this country? Massachusetts codified the Roe Act long before the Supreme Court decision. What can we do to ensure proactive legislative action instead of only relying on the courts? Can courts function even with dysfunctional legislative and executive branches in a democracy?
Well, 2 questions in that. One is, yes, we can trust the legislature if the legislature is appropriately selected. If the legislature is gerrymandered, then it enacts the program of the gerrymanderer. And I think we can trust most of the legislatures in the US. Really, the reaction to abortion is a classic example. I think that there was a real recognition of what the political pushback was. And the courts have still not been transformed by Trump. His appointees are still in the minority. What happens is that you hear about them because a very dogged group of conservative lawyers know where to bring the cases. They bring them in Texas. They bring them in Florida to some degree. They bring them in, Mississippi. But that's really not where, the overwhelming majority of judges are still appointed by other presidents. Another Trump term might change that. But right now, most are appointed by other presidents.
We can take two more questions. We have one here and one here.
Thanks very much for really putting it out there. I think what the previous question here said is they're starting to lose respect. And we see from Alabama and Texas that they're not even following the Supreme Court now. I mean, the fact that the Supreme Court was 5-4 about the border is really frightening. And then Texas won't even follow that. So how do we get respect for the law anywhere?
That's almost a historical question. I mean, I go back to Brown versus Board of Education and the paroxysms in the country that unleashed, right? And, you know, I'm old enough to remember what the pictures were like of the federal courts having to enforce desegregation in the face of an intransigent governor in Massachusetts, in the face of crowds that were stoning the buses. We got past it. And while there was a profound disobedience, ultimately the institutions held. So I don't know about you, but I have to believe that. I have to believe that. And I think that's true. This is a political answer, and I don't know that and I don't regard myself as a political pundit. But there really is, as Reagan described, a silent majority. There is a silent middle that is not necessarily voting in the Republican primaries, that is not necessarily on board with this. At least that's what people say. The components of that are all very different. But as I said, the Brown versus Board of Education was a period of upheaval in our country. The McCarthy investigations were a period of upheaval in our country. And ultimately, we got past that with some damage, but ultimately we got past that. So I'm an optimist. I'm an optimist giving the most pessimistic speech of my life.
And this is our last question.
When people ask me, how are you? I say, horrified, but trying to stay positive. And if you have a loved one with a terminal illness, that doesn't mean you stop fighting. I believe we've lost our democracy when the Supreme Court gave the election to Bush and took it from Gore, and he rolled over and did not fight. We were doomed to the war in Iraq. That was the Supreme Court's and Gore's problem. The question is, how can we bring our court back from corruption if we are not willing to enforce the law on Clarence Thomas and impeach him? Nobody wants to impeach anybody. They didn't want to impeach Trump. But if they ignored it, that allows it. So how do we get Clarence Thomas impeached for the actual financial crimes he has done?
Vote. Vote in the sense that if Congress changes, the Senate changes, the House changes, he could be impeached. But right until that happens, he will not be. We can't impeach. Impeachment is a political process, and until the legislature changes, that's not going to happen. So.
Well, we need to have someone to vote for, not someone just vote against.
Well, that's true. So today I announced my candidacy.
Be still my heart. Wouldn't that be fantastic? This was handed to me by Kate Kavanaugh, so I can't take credit for it, but this is spring and the promise of spring and the promise of what's coming. Thank you, Kate. Yeah. Could she run, if she would only run for president? I mean, think what we could do. We are so glad that you've been able to take that gag order off your mouth and speak to us with the integrity and the forthrightness that you've brought to this discussion this morning. We are so grateful. For those of you who have appreciated, there's going to be some breakfast back here, and it's still there. So take some home if it's gotten a little bit cool. Put it in a napkin, take it home, and warm it up. And also, I just want to say, join the league. because, you know, it is the good work of the league that makes this possible. So please, you know, join us in our efforts, and let's give Nancy one more big round of applause.